Here's a number that should get your attention. A $500 call to your association attorney today could prevent a $50,000 lawsuit next year, and most boards find out they needed legal advice only after the damage is already done, and by then, it's too late. Let's start with governing document amendments and the two opposite mistakes we see boards make. The first, boards that try to draft amendments by themselves using AI tools. And look, the output usually looks impressive: proper formatting, legal sounding language, the right structural elements. The problem is that it's often circular, it has holes in it, and it doesn't actually accomplish what the board intended. The dangerous part isn't that it looks wrong, it's that it looks right. So the boards adopt it and enforce it, and eventually find out the hard way that what they have isn't enforceable. When we see that, we stop the board and send them to their attorney, someone who has the full context of their specific documents, their jurisdiction, and their history. And that's not something we replicate. It's not something AI replaces. But here's the flip side, and this one costs boards just as much money in a different way. Boards that over-rely on their attorney for decisions that don't require one, calling legal counsel for routine judgment calls that belong to the board or frankly to their management company. That's real money leaving the association for questions that have practical answers, not legal ones. The goal isn't maximum attorney involvement, it's knowing which decisions need legal review and which ones need experienced management guidance. That calibration is something a good management company provides, and most boards don't have it. The second area where boards routinely guess where they shouldn't: architectural review and variance requests. Owner wants a deck. Owner wants to replace windows with a different style. Owner wants to install a generator next to their unit. These feel like judgment calls, and boards make them informally all the time. But here's what most boards don't realize. Inconsistent architectural decisions create legal exposure. If you approved a similar request 2 years ago and deny one today without documented reasoning grounded in your governing documents, you've potentially created a discrimination or selective enforcement claim. Architectural and variance decisions that deviate from the written standards or that set a precedent need legal guidance before you act, not after you're defending the decision. The third trigger: any dispute over who's responsible for maintaining or repairing something, the association or the unit owner. This is one of the most litigated areas in community association law, and it's almost never as clear as boards assume it is. Water intrusion through a shared wall, a pipe that runs through a unit but serves the building, a balcony that is exclusive use common element but structurally part of the building. The declaration may say one thing, the bylaw is something slightly different, and the actual physical condition of the property is something else entirely. Boards that guess at maintenance responsibility and get it wrong can end up paying for something that was the owner's obligation or forcing the owner to pay for something that was the association's. Both scenarios can end up in litigation, and both are preventable with legal opinion before the work is authorized. Here's the pattern we see over and over. Boards avoid the legal conversation because they're trying to keep costs down. Then one decision made without legal guidance costs the community 10 or 20 times what the attorney would have charged. The question isn't whether your association can afford to call an attorney, it's whether you can afford not to. And more importantly, do you know which decisions require that call before you make them? That's exactly the kind of guidance a professional management company provides. Not just processing payments and scheduling maintenance, but helping your board recognize when you're about to step into territory that requires expert legal review. At Managemax, we know that effective community management is built on transparency and systematic excellence. We provide full-service HOA and condominium management across Southeast Michigan, handling everything from accurate financial reporting to proactive maintenance. Our goal is to reduce the burden on your board while protecting your property values. If you're looking for a partner who values accountability as much as you do, visit us at managemaxproperties.com. Let's build a stronger community together.